Podcast is now starting. All attendees are in listen-only mode.
Okay, I'm sorry, everybody. I was muted. Welcome, everybody. We are honored to have some great presenters this morning or this afternoon, and not only a fun topic, but some excellent human rights knowledge. Uh, uh, sorry, experts. Sorry, and. First, I'd like to just introduce the Alaska Small Business Development Center, and then we will get started with A Dog Walks Into a Bar, what Alaska businesses need to know about service animals. So first, the Alaska Small Business Development Center has been assisting small businesses in Alaska since 1986. We have 7 locations throughout the state, including Anchorage, Fairbanks, the Mat-Su Valley, Soldotna, Seward, Homer, Juneau, and we also have a rural outreach program that provides services in all other areas of the state. We're funded by the SBA, Small Business Administration, the state of Alaska, and various local government organizations. The University of Alaska Anchorage and we are hosted by the University of Alaska Anchorage, and as such, we're UAA employees. SBDCs are also nationwide. There are approximately 1,100 centers located around the country. So if you want to move to another state, we can help get you connected to your nearest SBDC in that state. All SBDCs nationwide offer the same 3 core services: free, confidential, one-on-one business advising, low-cost workshops, including in-person, like today, and live webinar, like today. And this webinar is also going to be recorded. Access tools and resources are also something that the Alaska SBDC provides, including business templates, our business plan templates, financial projection templates, and also advisors have access to additional expensive subscriptions that they can help you access. The Alaska SBDC also has several partner programs, including PTAC, or now it's called APEX, and they provide assistance with government contracting. There is also another program that we have called TREND, and they provide assistance with technology-based inventions. And we also have what a fair number of people are aware of is Buy Alaska program that provide assistance online. So now that we've got that covered, let me just introduce Alex Reuter and Rob Corbusier. Take it away.
Hello, everyone. Thank you for joining us today. My name is Alex Reuter. I'm a special projects attorney with the Alaska State Commission for Human Rights. And before we get into the gist of it, we're going to kick it off with our executive director, who's going to run us through what the State Commission for Human Rights does.
So we enforce Article 1, Section 3 of the state constitution. The second sentence of that states that the legislature shall implement this section, and the Human Rights Commission is the implementation of that section. We are one of the oldest agencies of the state of Alaska, created in 1963, so we actually predate Title VII of the Civil Rights Act. We enforce the Alaska Human Rights Act, which is codified in AS 1880. We have jurisdiction over 5 areas. Those are employment, which is the bulk of our cases, places of public accommodation, sale and rental of real property, credit and financing, and practices by state and local governments. So if someone is discriminated against based on being a member of one of these protected classes, or being a member of a protected class, such as age, race, sex, sexual orientation, and gender identity for at least employment cases, national origin, religion, physical, mental disability, pregnancy in some areas. Within one of the 5 subject matter areas that we cover, a person can come to us, talk to an investigator. If we determine jurisdiction, we can accept a complaint, conduct an investigation, and particularly for employment cases, we have the ability to provide compensatory damages. And we are a team of investigators as well as attorneys, so we will litigate this for you at essentially no cost. We are essentially the civil rights agency of the state. One of our statutory functions, though, is to prevent discrimination. And so we're doing as much public outreach as we can. One of the things that I wanted to start a couple years ago was doing kind of monthly brown bag lunches. So on different topics. So I was excited when the Small Business Development Center approached us, or whether we approached them, but we've done collaborations in the past. This is the first one of these. And we are also happy to bring in the Anchorage Equal Rights Commission, which we've also all collaborated before in the past. We're trying to expand some of these other collaborations. And so we are joined by Gita Franklin and Spencer. Spencer, what's your last name? Rose. Spencer Rose with the Anchorage Equal Rights Commission. But I'm going to let Alex, as our special projects attorney, take over most of the presentation.
All right, now to get into the stuff that everyone came here for, the excitement of service animals. All right, so quickly, I'm going to run through what we're going to discuss today. We're going to talk about what a service animal is, what things that are like service animals and what aren't service animals. We're going to talk about the civil rights, what can and cannot be asked about a service animal, when a service animal can be denied entry, special circumstances around service animals and emotional support animals in housing, and special circumstances in air travel. And let's get on with the show. So first and foremost, what is a service animal? So our act, the Alaska State Human Rights Act, and the ADA defines a service animal as a dog or miniature horse trained to do work or perform tasks. So that means, if they are guiding someone, if it's a seeing eye dog, right? They could be pulling mobility devices, helping people in wheelchairs or other situations move forward. They can fetch objects. They can alert people with hearing impairments to sounds. And they have to be serving this function, doing this work for a person with a disability. I know I said dog or miniature horse. As I go on, I may say service dog. Know that in this instance, it also applies to miniature horses, but that's rare to see in Alaska. So other things, while not strictly a service animal, there are other animals that perform tasks that fit into these quasi-categories. The first one being alert animals. These are animals, under state law, it can be any animal. Under the federal law, it has to be a dog or a horse that warns someone with a disability of something that could impair one's vital bodily functions. So this can be panic attacks, seizures, hypoglycemic episodes. They can detect allergens, things of that nature. While they may not be performing a specific function, they may not be guiding someone around, they may not be retrieving items for them, they still can sense things that is important to someone with a disability.
And so on that note, the defining characteristic for an alert animal is similar to a service animal in that there has to be some component of training that relates to the person's disability.
And then the final one that is very popular is emotional support animals, an animal that does not perform a specific task, but rather provides emotional support, well-being, comfort to someone with a disability. I know you're going to have questions. We'll get to this at the end. So, first off, under the ADA and Alaska law, places where the general public are allowed must allow equal access for individuals with service and alert animals. It means that they have to be treated exactly the same. You can't charge them extra fees. You can't require them to remain in a segregated area. You can't treat them any different than you would any other person. Failure to do so can result in prosecution for discrimination on the basis of a disability. So, if you own a business, a restaurant, whatever, and someone shows up with a service or alert animal, what can you, as the business owner, ask the person with a service or alert animal? Not much. There are 3 questions, only 2 for service animals. First, is this animal needed due to a disability? The fact that you can't discriminate against people using service animals doesn't mean that you can't, not allow dogs in your restaurant if they're just pets. So you can ask someone, is this animal a pet or is it needed due to a disability? Second question, you can ask, what work or task has this animal been trained to perform? And then only if it's an alert animal, so if they say to the second question, oh, this animal alerts me of, an allergen, it lets me know if I'm about to have a seizure, right? You can say, may I see written verification from a healthcare provider of this animal's purpose? You cannot do this if it is a service animal, like a seeing eye dog, or a guidance animal, a mobility horse, things of that nature. That is it. Those are the 3 questions you can ask. So, what can you not ask about? Like I said, it's basically everything else. But just to briefly run over things, you cannot ask for a demonstration of the service or alert animal's training. If you say, I'm not really sure if it's a seeing eye dog, can you show me how he would guide you? You cannot do that. That is treating someone with a disability and a service animal differently than someone else. You cannot ask for proof of one's disability. Some disabilities are obvious, they can be seen, and some are not. You can't ask proof regardless. You cannot ask for any form of licensing of the service or alert animal. What the legislature is trying to do with that is ensure that people with service animals are not treated different than people without service animals. You can't ask them to, have their papers presented upon entering a business. Additionally, you cannot require service animals to be wearing vests, harnesses, muzzles, or anything else of that nature. Finally, businesses cannot deny a service animal entry due to a dog's breed or alert animal species. Sometimes we get people who are like, the only seeing eye dog is a yellow lab. That is not true. It can be any breed imaginable. We actually have someone that's very close with the commission that used an Irish setter, whatever, a different specific breed as a seeing eye dog for a number of years. So, if that's the case, when can a service or alert animal be denied entry? There is behavior that is so extreme that as a business owner, you can say, hey, I need to get this dog out of here. First off, if it is out of control and the handler does not take action. If it is doing something that would be so disruptive to the service that you provide to make it basically unusable, that's when you can ask them to leave. So an example is if a service or alert animal is, say, howling during an opera and won't stop. That defeats the purpose of anyone else being at the opera. If the handler doesn't take action, cannot get them under control, you can say, excuse me, would you please leave the premises? Get the dog out of here for right now. Another example, we've had this before. If a service or alert animal is standing on the table in a restaurant and the handler is feeding them by hand, that is not allowed. That is unhygienic. That defeats the purpose of a restaurant that's causing a disservice for everyone else. You cannot ask that. And an incredibly common one, if a service or alert animal is not housebroken. If they are urinating or defecating on your floor, 100% of the time you can say, please leave. Additionally, if a service or alert animal poses a significant health risk that can't be mitigated. Now this one can be a bit wiggly, so let me explain. If it is say like a sterile environment, like a hospital or an iron lung, where a dog with pet dander being in that environment puts people's lives at risk, it's completely acceptable to not allow a service or alert animal into those locations. And let me clarify that when I say sterile environments like a hospital, it has to be a sterile environment in a hospital proper.
Such as an operating room. Like a clinical situation is more than likely not going to count as a completely sterile environment.
Exactly. If someone's in the waiting room, if someone's going to the cafeteria in a hospital with a service animal, that service animal should not be excluded from those areas simply because some areas of the hospital may be sterile and having a dog in that environment could pose risks. Now, what does not count, and some people frequently bring to us, are if you have an employee who is maybe fearful or allergic to dogs. That does not mean that you can ban all service dogs entry. Another thing is if accommodation would significantly alter the nature of the provided good or service. If you are providing something as a business that literally a dog just cannot do, you can exclude a service animal, right? I use the example of a single person kayak tour that can't be changed to fit a dog. You have one person in a kayak, you can't put a dog in that kayak either, right?
A sled dog tour would be another good example of
Great
that.
example.
I mean, if you're operating a sled dog operation and you got a service animal there, that is going to distract what all the other sled dogs are doing, and that's going to fundamentally alter the nature of the service.
However, when we say that, it has to be fundamentally altering. So what does not rise to that level is, like, say, a fancy restaurant atmosphere, and they're like, if a dog is in here, it would cheapen the vibe. It's not the case. It has to fundamentally challenge what the business is providing, or place of public accommodation. Change, yes, sorry. All right, now we're going to talk about the exceptions. The two big exceptions provided under the law relate to housing and air travel. First and foremost, we're going to talk about housing, and especially emotional support animals in housing.
And to start with, let's clarify, emotional support animals do not get the same levels of protections as service and alert animals. Yes. So they can be excluded from places of public accommodation because they are not trained to perform a task for the person with the disability.
Everything we just discussed only applies to the service and alert animals. So those are those animals that are trained to do a specific task, like you said, to benefit someone with a disability. Here, we're talking about emotional support animals who do not perform a specific task, but can provide emotional support, well-being, or comfort to someone with a disability. The Fair Housing Act requires landlords or other housing providers to allow for reasonable accommodation for emotional support animals. This is in addition to everything else. So just because we're adding this on to housing, this does not mean that you can exclude, say, a seeing eye dog from housing. So, first, if a tenant or similar person requests to keep an animal not trained for a specific task in connection with a mental or physical impairment, in this instance, again, we're talking about emotional support animals, first, a tenant must show that they have a disability. So this can be proven in a bunch of different ways, including doctor's note, government disability determination. So if someone is on, I don't know, VA benefits, or someone is receiving disability, or other obviously observable disabilities. If you meet them in person and they lack arms, you don't need to say, I need to see a doctor's note that you don't have arms. A property owner cannot ask for full medical records, and the disability information must be kept reasonably confidential. You can't be telling everyone about a disability that someone may have. Once that first step is met, we go second, a tenant must somehow show that the animal would assist with burdens from the disability or benefit the treatment of the disability that they previously proved. Typically, this information should come from a medical professional with specific knowledge of the tenant's case. In an ideal situation, it would probably be someone like a general practitioner, right, who says, I know this person has PTSD. This dog will benefit their PTSD. I have recommended the usage of this dog. But that is not strictly required. Letters from the internet are typically not accepted unless they come from telehealth consultation. After COVID, a lot of people now are meeting online with physicians. That should still work. Just the fact that it's on a website or coming from an email does not invalidate this proof that an emotional support animal will benefit an individual. However, if it's coming from, getmeanemotionalsupportanimal.com, you can probably say that that is insufficient evidence. So, if both of these criteria are met, it's proven that they have a disability, and they've illustrated how having an emotional support animal will benefit the treatment of this disability, a reasonable accommodation should be granted without an extra charge if the animal is typical to households. So, if someone comes to you with something crazy, they need to have evidence for that. Now, you may be asking, what is typical to households? There aren't hard and fast rules, but HUD considers the following animals to be those that are considers that animals typical to households to be those that are commonly kept as pets or for non-commercial purposes. So dogs, cats, turtles, hamsters, gerbils, small birds. probably does not extend, to cows, things of that nature. However, if a more exotic animal must serve a specific purpose that only a specific animal can provide, that accommodation should be given. So the one that is frequently brought up is capuchin monkeys. Capuchin monkeys, they have opposable thumbs. They can do stuff with their hands. If this animal is needed to sort of, help people with dexterity issues, then in that instance, while a capuchin monkey is not an animal traditionally kept in households, it should still be granted in this circumstance. Regardless of the species, however, if an animal is dangerous or would require a fundamental change to the nature of the premises, it doesn't have to be accommodated. If it's a porpoise and they need to install like a massive tank, you can't say, you can't have a porpoise. If it's, I don't know, a boom slang, you don't need to let that come in. All right. And now that we've discussed housing, we're going to talk about air travel. There's something called the Air Carrier Access Act that puts slightly different service animal regulations on airlines. While previous rules required the accommodation of a wide variety of emotional support animals, this has changed with 2020 agency rulings. So you may have seen there were a whole bunch of stories right before COVID of, the peacock or the potbelly pig running down the aisle causing problems. That is no longer the case. Airlines are only required to accommodate no more than 2 service animals per passenger. Emotional support animals, as of 2020, may be treated as pets by airlines. Air carriers are required to allow a service animal to be leashed due to the unique circumstances of being on an airplane. You're allowed to require confirmation that the dog is vaccinated, and you're allowed to require the contact information of a service dog's training organization and veterinarian. Again, this is only for air carriers. This does not extend to anything else. And with that, that was the majority of what I did. That went by faster than I was expecting.
Video.
I can play the video. Let's ask questions first. You want to watch the video?
Watch the video. Video's fun.
All right. We have a very silly sort of thing attached to it. There was a video where someone brought their service velociraptor. I think, is that making sound? Potentially.
The laptop's muted.
I do like that. It's going to be off the sound.
Video.
No. All right. Well, in the video, someone's attempting to get a velociraptor onto a plane as a service animal. You can see why that would be a little silly. But with that, if that's not cooperating, let's go back and talk about questions that people might have. Marianne, is anyone in the chat? Or if anyone in the room has a question?
We don't have any questions online. Ginny. Oh, Ginny's our advisor, so I can say her name.
Earlier, when you were going through the definitions and you talked about the emotional support animal, you mentioned that the emotional support animal has to be for someone with a disability. So it can't just be like me without a disability walking on with my dog saying.
No, you don't get to decide that you have your own disability and I need to have an emotional support animal. It still needs to be connected to a disability and some kind of a provider needs to recommend it.
Now, that being said, the definition of disability is very broad, right? So, if you have someone who says this is a person with, generalized anxiety, that could qualify as a disability depending on the circumstances around it. Just because, you don't have something that you would, be written about in a,
The biggest distinction though is the emotional support animal does not get the same level of access that the service or the alert animal does. I mean, there is definitely a big teardrop between kind of the tier 1 service and alert animal versus an emotional support animal. Emotional support animals really only get protections for housing.
Excellent. Thank you. Are there any other questions, whether in person or on the web? Okay. Alex and Rob, is there anything more you'd like to add?
Sure. Let me take you to the end again. I went back to show the service animal definition because I thought it was going there. I'm sorry. But if you have further questions, please don't hesitate to reach out to us at the Alaska State Commission for Human Rights, or reach out to the Anchorage Equal Rights Commission if you're in Anchorage. I have both of our emails, our websites, and our phone numbers up. You can scan the little QR code.
Screw that up
a little bit, but it's
Sorry.
okay. Additionally, if you have any questions that can be solved by some further reading, I've included some links in here. The HUD guidance, the DOT guidance on air travel, US DOT service animal air transportation form. I know some airlines are starting to require that you file this prior to bringing an emotional service support animal on a plane. If you're wondering, that's where it is. And then I also have some forms with our State Commission for Human Rights guidance on service animals. And if there's nothing else, I want to say thank you for everyone for coming. Oh, I actually think I have a question in the room.
I'm so sorry.
No, that's
It's okay. It's recorded. Give me a
great.
copy of the presentation.
Perfect. Hiring practices with someone who has a support animal service or EF.
Sure. So a lot of that is going back to the same rules as public accommodation. An emotional support animal is not covered in hiring practices.
No, you can exclude an emotional support animal from the workplace. If it is a service or alert animal, you cannot exclude that from the workplace.
So
Now, again, so the same rules where it's talking about like if it fundamentally changes the nature of the service provided, that same rule that applies to people coming in with service animals applies to employees with service animals as well. It depends on the situation, but like, you know, if it's a case where
Well, there's a direct threat. So,
Exactly.
I mean, talking about like an operating room. I mean, an operating room, a dog is going to be walking around with paws on the ground, is likely going to be bringing fecal matter into the sterile environment of the operating room. That would cause direct threat to the patient.
Yep.
So you can exclude the service animal or alert animal from an operating room. A clinical setting is different, though. Clinical setting is not a sterile environment. And
what
maybe
if it's a veterinary clinic where there's dog-dog interaction?
So that could fundamentally alter the nature of the service provided. So the other example that we used was if you're running like a sled dog tour thing, a person with a service animal showing up at that service dog at that sled dog operation, that's likely going to be a distraction to all of the sled dogs there. And then the sled dogs are going to be excited about their new friend and not going to want to go run. And so that would fundamentally change the nature of the service.
now in the same breath, if the position that you're hiring for would allow for that service animal to be there, even if it could fundamentally change the nature of the service, say if it's a sled dog tour, and even an employee who wants to bring their service animal as a tour guide, that could be an issue. If someone has a service animal who is doing like your finances and is not out by the dogs, that accommodation most likely should be given.
And the other question we get is, well, what if I have an employee that has a serious allergy to the dog? All right, you have to figure out a way to accommodate both disabilities. And that can be tough, but you need to figure that out. So, I mean, I just had a opinion from the commission where we had a person with a service animal who was a disabled veteran. And the veteran was going into an Army surplus store. The owner of the Army surplus store was another disabled veteran who had a series of medical conditions, this is all in the record, as well as he claimed a serious allergy to dogs. And they excluded him from the business. It's like, well, you can't do that. You have to figure out a way to accommodate both. So that means either the owner needs to be wearing a mask, or the owner needs to set a specific time for the patron to come when the owner will not be present, and then the owner can have a different employee there. And maybe that also is going to require the owner to do an additional round of cleaning after the service animal leaves. But either way, you got to figure out a way to accommodate both disabilities.
I think I also forgot to mention it, but with public accommodations, if you do deny entry to a service animal, right? Like if a service animal has to be asked to leave from, say, like a store or something because the service animal is freaking out, you should provide opportunities for the person with the service animal to conclude their business, right? So if they're like, hey, like, I know you normally don't do this, but can I like grab my food and leave? I know I already paid for it, but my service animal now has to be whatever, 86th from a restaurant. As much as is possible, try to allow the interaction to conclude. A lot of this just goes down to do your best to be as accommodating to people with service animals as you can, as they are, equal members in society.
But again, if the service animal, if the dog is unruly,
yeah,
you can still kick the dog out.
Absolutely.
Probably not, but you are allowed, people with disabilities are allowed to train their own service animals. So that we've also had those circumstances. And honestly, that Alex can talk about his anecdote for why we called it a dog walks into a bar, but we actually saw an increase in service animal related complaints coming against the alcohol service industry. There's been a rise in general of disability related complaints against places of public accommodation, and a large part of it has been driven by more people with service animals. But in particular, it was like the alcohol service industry wasn't getting it.
Mm-hmm. And we've also had instances where, like Rob mentioned at the beginning, we have coverage over state and local government practices, and so there have been times where there have been HOAs or local ordinances that have been like, dogs aren't allowed in restaurants, and we have to be like, if you're applying that to a service animal, that is against Alaska law, and we will yes, exactly. So we will bring that up, and we have gotten those regulations removed from the books. So very broad coverage in that way. Anyone come up in the chat, Marianne?
No questions online yet.
Do you guys have any resources on best practices for accommodating people with service animals?
Exact. At the end of this presentation, I've included our guidance along with the guidance of Department of Transportation, HUD, Housing and Urban Development, and since you're in person, I'll give you some after the thing. But yes, we do have sort of best practices. Sticking to those questions is going to be your best bet, and keeping us in mind. We are here to prevent discrimination. So even if you do run into an issue where you're like, I have a question about this, don't hesitate to reach out to us, and we can try to provide preliminary advice pointing you in the right direction.
Okay.
Yeah, I think if everyone's good, we're going to kick it on over to Marianne. I think she's going to close us out, if that's okay.
Yep. Thank you, Alex. Okay, well, everybody, thank you very, very much for attending. After this workshop, we will email you an evaluation survey, and that's your chance to help make these classes much better in the future, and we do read all of the evaluations. In addition, I want to invite you back next month, May 23rd, 12:15 to 1 p.m. for Alex, Rob, and we also will have Keiko, or is it Kiyoki, sorry, the executive director of the Anchorage Equal Rights Commission. So, and these will be monthly brown bags, and we look forward to seeing you in May, every Thursday, every third Thursday, right? Yep, all right. Okay.
And they're recorded and available on the SBDC website, and they should be posted on the State Commission for Human Rights website as well. Additionally, if you have recommendations for topics that you're interested in regarding discrimination in the workplace, public accommodation, whatever, please don't hesitate to reach out to us. We're always looking for recommendations on topics to pursue in the future.
Okay. And oh, and I didn't mention the title of next month's brown bag. It will be Legal Actions and Contractions, Pregnancy Discrimination and Accommodations for Alaska Businesses. So, all right, without further ado, thank you everybody. Have a wonderful day, and we look forward to seeing you next month. Bye.